You are watching Teso Vibes TV.
Now we have been having a system whereby there are two sets of courts. You have the conventional courts and you have those who sit at Machindi. And they pronounce themselves very clear on this. That was never the intention of the framers or the progenitors of the Constitution. In as much as they recognized the historical significance or importance of a general court martial in instilling discipline within the military force, when it came to dispensation of justice, the justices were very, very clear on this. So, Parliament exceeded its mandate in enacting the UPDF Act in 2005 by creating two things. One, the provision, that is 117, which is now 119, that vested mandate in the General Court Martial to try civilians of two categories. Those who were said to have brought themselves within the purview of the General Court Martial by either abetting crimes committed by serving military officers or those who wielded weapons which had been considered the monopoly of the UPDF. Now, that animal, we asked when we were in the General Court Martial, that animal, a weapon which is ordinarily the monopoly of the UPDF, which one is that? It was the same question before the Supreme Court. Which one? It has never been defined. So in other words, there is no weapon which is a monopoly of the UPDF. And that's where Parliament went wrong. They also went wrong in that suggestion that even soldiers who are charged with capital offenses that attract serious and grave penalties like a death sentence or life imprisonment, that they can be tried by a tribunal which was not competent, manned or presided over by people who did not have necessary qualifications. So that's why they had to nullify Section 197 of the UPDF Act, which created the General Court Martial and never defined the qualifications for the members of the General Court Martial, save for the chairman, whom they said shall be at the rank of Lieutenant Colonel. But Lieutenant Colonel, of what qualifications? You can be a Lieutenant Colonel, but not a lawyer. You can be a medical doctor, you can be anything. But as long as you are Lieutenant Colonel, that you could qualify to be the chairman of the court. And also, so, in other words, there are systemic problems or defects within the system which the justices faulted. So, in a nutshell, the point I am driving at is that the General Court Martial was disbanded because the provision that created it, Section 197 of the UPDF Act, was nullified. So, as we speak today, there is no General Court Martial. So if in your speak or in your talk, you refer to that outfit, the residue of it, as a General Court Martial, your statement would be unconstitutional. It would be to the amount to contempt of court if you call this so. So from today onwards, please, nobody should be speaking about the General Court Martial. You can add adjectives as you want. The defunct General Court Martial, the former General Court Martial, the whatever, or whatever they let. So there is no General Court Martial as of 31st January 2025. That is the new legal regime. That point I wanted also to emphasize it. Now the last one is the issue of amendment to the UPDF Act. In his statement, Mr. Museveni said they are going back to the drawing board. They are going back to Parliament to revisit the UPDF Act. Of course, there are a number of provisions, Section 2, Section 117, Section 100, that's a number of return of provisions that were nullified by the Supreme Court. So now he's saying they are working with the Attorney General and all those people in government to address those flaws in the Act and then come up with a new one. Take a note of the fact that there is a bill already pending before Parliament for the amendment of that same Act. There is one already where I think they wanted to legalize SFC as a unit of UPDF and a couple of other things they wanted to fix. So you can see they have already been tinkering with the UPDF Act. Now he's saying probably that they are going to withdraw the bill. That's what I think. Implicitly, he's suggesting that they are going to withdraw that bill and part of it and resubmit it to Parliament. We need to caution them. In law, there is what we call structural interdicts. Structural interdicts, these are consequential directives given by court after analyzing flaws within a system, defects within a system, and say, please, we have diagnosed this problem within the system. Do a surgery to the system and correct them as follows. This is what court observed and said systematic, they are systemic problems, not systematic, systemic problems. There are those issues which needed to be addressed, and they guided properly on how they can be addressed. So, if Mr. Museveni is going back to amend the law, well and good, but it must pass the constitutional test. It must pass the constitutional test in two ways. Number one, he should not in any way attempt to overturn the decision of the Supreme Court. That is the command in Article 92 of the Constitution, which is very, very clear, that Parliament shall not enact any legislation that has an effect of altering or in any way affecting a decision of court. So once court has pronounced itself on a matter, Parliament can only reinforce the decision of Parliament, but not to upset it. Or the decision of court, rather, not to upset it. So, the talk now, this is now where the issue comes in, the issue of the disciplinary committee. That defunct General Court Marshal cannot automatically morph into a different outfit, even if it is to operate as a disciplinary committee, because the provision that created it with Section 197 of the UPDF Act has since been nullified. Therefore, for it to morph or to transform into something else, from a General Court Marshal with a wide mandate to a committee with a limited mandate of discipline within the force, it has now to be the Parliament. And the court guided that if Parliament is doing it, they should be, they shouldn't be oblivious of the limit under Article 210 of the Constitution. Under Article 210, which gives Parliament the mandate to make a law regulating the functioning of UPDF, is very clear. It's about to discipline. That's what they say. It's about to discipline. And they should not in any way provide for sanctions, penal sanctions that involve custodial sentence or any other penalty like execution, death, or whatever, and so on and so forth. That is a preserve for the conventional courts. Whereas, under Article 210, if Parliament is to make a law that passes that test, whereas it should be limited to disciplinary actions that would entail like caution, or dismissal from the force. It can be with the disgrace. And it's obvious, it's just logic. Many of these entities have got disciplinary units, like the prisons authorities. Do they send people to the gallows? The prisons, the police, the police standard unit, the professional standards unit. Yes. Even Parliament, the Committee on Rules and Discipline. Can they remand you? Can the chairperson, Honorable Katuntu, remand an MOP, also convict an MP and send him to the gallows? It's only logic. So that's the way it should operate. That was the guidance. And they indicated, they went further and said, if they want to add them extra jurisdiction to handle issues to do with the civilians and even serving military officers who commit those offenses within the realm of the penal code, those ones should be handled by competent people who have gone to the law school, and not only to the law school, but who are qualified to be judges of the High Court, because to be a judge of the High Court, you must have practiced for at least a period of 10 years to be able to try capital offenses. That's why you cannot be tried by magistrate court, because there are no qualifications of that nature, that for you to be a magistrate or a chief magistrate, you must have practiced for a particular period. So therefore, if a chief magistrate of Uganda Road cannot try Dr. Besigye on a capital offense, who is this man, Sujui Brigadier General Freeman Mugabe, who has never gone to the law school, to try Dr. Besigye on a matter which involves death sentence? That is an absurdity. So this is where we take exception to General Kaguta Museveni in his statement. He said, you see, because he has indicated they are going to defy, he said, you see, if some jurisdictions provide for a law on homosexuality, where a man can marry a fellow man, why not having a system here where people who have voluntarily brought themselves within the ambit of the of the military law to be subjected to martial law? That is the analogy was drawing. We are asking with General Museveni, with all due respect, please, I'm sorry to digress a bit. The Arsenal fans have got this cliche they are using to send a message to Haaland. Please stay humble. Stay humble. Yes, the Arsenal fans have told Haaland, please stay humble. We are telling General Kaguta Museveni, please stay humble. Just swallow your humble pie. You lost it on Friday. There is no way you are going to resuscitate the general court martial within the existing constitutional framework. I'm assuring you. There is no way. Let him be advised properly by the Attorney General and all those legal gurus he has in his government, if they still exist there. There is no way he can resuscitate the defunct general court martial within the existing constitutional order. It is absolutely impossible. I want to assure him. Parliament cannot do it. Under Article 92, it's very, very clear. You cannot. So that one, we wanted to make it abundantly clear to General Kaguta Museveni, to ask him to swallow his humble pie. And